Good day, Crime Talk aficionados. The day kind of got away from me, so we've got a quick show for you today. First, Bryan Kohberger challenges having to pay restitution because public donations. The Markel family addresses Donna Adelson's statements at sentencing. A trial date is established for the case of Sanchez, and the Supreme Court is going to examine whether if you smoke pot, you can't have a gun. This day in legal history, quote of the day, and our dumb criminal. Let's talk about it.
Lawyer.
Good day, everyone. My name is Scott Reich, and this is Crime Talk. Thanks for joining us. You know the drill. Subscribe if you haven't. Like if you do. Leave me a comment below. Hit that bell for notifications, and check us out on any of your favorite podcasting apps. Before we get to the docket, let me remind you to go to crimetalksearch.com. Sign up for that background subscription today. Find out everything you want to know about somebody, but maybe you were just afraid to ask or not sure where to turn. Literally thousands, tens of thousands of public databases are searched literally while you wait. You get that report emailed to you. It's going to have all kinds of information that you need. Social media sites, telephone numbers, email addresses, criminal history, property ownership, everything you want to know about somebody, married, divorced, are they on a sex offender registry? Go to crimetalksearch.com. You'll be happy that you did. Also, let me remind you, check out the merch. These things, I don't know how many we sold over the weekend, but there was a big stack out there going out in the mail today. Go there, check it out. Lawyer. You won't be disappointed. They're soft. You can sleep in them. You can wear them. Go do it. And oh yeah, you can get your cool keychain as well. All right, let's go ahead and open the record for Monday, October 20th, 2025. And Bryan Kohberger, that's right, says, I'm not paying. So, convicted murderer Bryan Kohberger is contesting additional restitution payments to the families of the University of Idaho students he killed, asserting that public contributions via the GoFundMe have already covered their expenses and that his lifelong incarceration prevents him from making payments. That's right. The 30-year-old former criminology PhD student who is serving multiple life sentences for the killings of Kaylee Gonzalez, Madison Mogen, and Zeno Knodel and Ethan Chapin. Now, in the early morning hours of November 13th, Kohberger entered the off-campus residence back in 2022 and fatally stabbed all four students. Now, in a court filing submitted dated October 7th, Kohberger's legal team contended that he should not be required to provide further compensation sought by the prosecutors for the families of the Gonzalez and Mogen family, given that the funds raised through various GoFundMe initiatives have already been given over to them. The defense also emphasizes, hey, Kohberger has an inability to pay due to his imprisonment. The filing states, quote, the additional funds requested do not constitute an economic loss under Idaho Code, Section 195304. As Steve and Christy Gonzalez and Carrie Laramie have obtained substantial support through multiple GoFundMe campaigns that were explicitly designated for and addressed the claimed expenses. It further notes Mr. Kohberger lacks the capacity now or in the future to fulfill restitution obligations as he's serving 4 consecutive life sentences plus an additional 10 years. And under the terms of the plea agreement, Kohberger consented to prosecutors pursuing restitution for the families to offset funeral costs and other expenditures reimbursed by the Idaho Crime Victims Compensation Fund. But at his July 23rd sentencing there in Ada County, Judge Hippler mandated payments include $251,277.50 in fines and fees to the state, $20,000 in civil judgments per the family, and an additional $28,956.88 for funeral and related costs via this compensation fund. Now, on September 22nd, the state submitted a sealed motion requesting an additional $20,409 for the Gonzalez parents and $6,920 for Mogen's mother, Karen Laramie. According to the unsealed defense response, these amounts pertain to travel, lodging, and urns for the victims' remains. GoFundMe campaigns were established to assist the families in attending court proceedings, including a trial originally set for August in Boise after a venue changed from the Latah County at the defense's request. This relocation necessitated extended travel and accommodations for the anticipated 3-month trial, and the defense filing referenced specific campaigns, one joint effort raising $73,000 for both families, and another for Mogen's family traveling, yielding another $48,815, and one for the Gonzalez family generating $85,000. Now, following Kohberger's July 2nd plea, which avoided the death penalty and canceled the trial, the Gonzalez family announced on Facebook their intentions to refund donations earmarked for the trial attendance. Nevertheless, the defense argues that the families incurred no net economic loss for these expenses, and the state's motion lacks detail as to whether refunds were issued or requested. And Kohberger has waived his appearance for any forthcoming hearings on this issue because he doesn't really care, but it's good legal lawyering going on here. Now, recently, the Gonzalez family posted on Facebook about transferring Gonzalez and Mogen's remains into urns, noting that each family is possessing urns for both victims to ensure they remain together, reflecting their close bond. This dispute arises amid ongoing release of investigation materials, including witness statements, early police leads, and reports of potential stalking of other victims. Now, despite the extensive evidence, no motive or link between Kohberger and the victim has been established, and he's declined to speak at his sentencing, so we may never know. He is currently incarcerated at the Idaho Maximum Security Prison, where he has lodged many complaints regarding inmates treating him unfairly. So, listen, this may sound like one of the coldest things we probably have said in a long time, but the defense is probably right about this, okay? There's certain things under the statute that the defendant has to pay for, and there's certain things that are not. And since there were these other funds, there's no out-of-pocket expenses. So the families probably shouldn't be entitled to any of these expenses. They haven't incurred any expenses, all right? And I literally dealt with this issue just the other day in court. Clients getting sentenced, victim's family says, we had to relocate, and we put in a security system. And I said, Judge, there's no causal connection between the security system and the crime. It's not where the crime occurred. There's case law that says you don't get to get reimbursed for a new security system to feel safe. I mean, feeling unsafe is kind of natural when you're the victim of crime. And our Supreme Court has said you don't get to be reimbursed for that. And I'm going to win that one, I do believe. So the reality of it is, I think the defense is correct. If there were GoFundMes and they've taken the money or they refunded it, but the trial was canceled. So unless there was a non-refundable fee for $48,000 for hotel expenses, which I doubt there were, it shouldn't be passed on to Kohberger. I know that sounds crappy. Some people are going to say, he should just pay it. He's never going to pay it anyway, so what does it matter if they impose it? Legally, they're not entitled to it. And if they want to put together some urns, they can do that. But that's not something that the defendant has to pay for. That's just the way it is, ladies and gentlemen. Next, the parents of Dan Markel have issued a statement in response to remarks they described as disrespectful and delusional delivered during Donna Adelson's sentencing hearing. Now, on October 13th, Adelson received a life sentence without the possibility of parole for the conviction for orchestrating the murder-for-hire plot that resulted in Markel's death, her former son-in-law. She became the 5th individual convicted in the connection with that case, which also involved her son, Charlie Adelson, his former girlfriend, and 2 hired hitmen. Now, during the hearing, Donna Adelson and her husband, Harvey, spoke to the court, asserting her innocence while seemingly directing criticism towards the victim's relatives. They were good pointed sentencing. Harvey stated that the Markel's parents had claimed no access to the grandchildren, yet Wendy Adelson, Donna's daughter and Markel's ex-wife, had provided him with photographs, videos, and correspondence documenting their interaction. He further accused them of fabricating details about the grandchildren to the court, noting the profound grief they endured from losing their son. Police have also indicated that disputes over custody of the children shared by Markel and Wendy Adelson were the primary motives for the crime. Now, Ruth and Phil Markel, Dan's parents, observed the proceedings virtually and expressed astonishment at the Adelson's comments, labeling Harvey's remarks as deeply regrettable. In a prepared statement, Ruth sought to clarify the facts. Our family experienced a complete severance of contact with the boys for 6 years. Subsequent engagements subsequent engagements have been restricted, primarily consisting of supervised video calls arranged by Wendy and brief in-person meetings. Ruth also mentioned that Wendy had declined to disclose their residential address, required all correspondence and presence for the children to be routed through their legal representatives. Donna Adelson's praised her former son-in-law as an honorable individual and a devoted parent. However, Ruth contended that Donna had displayed no genuine sorrow over Dan's passing, instead exhibiting a lack of concern regarding his killing. Ruth characterized Donna's courtroom tears not as regret for the loss of life, but as self-pity over the repercussions of her actions. There you go, ladies and gentlemen. No one's ever going to be happy at a sentencing. Sometimes it's better just not to say anything, particularly if there's going to be an appeal, which is what the Adelsons should have done. Next on the docket, Mark Sanchez. He's got a court date. A court has scheduled a trial for Mark Sanchez, the former NFL quarterback and current sports commentator, in connection with the assault incident that he's been accused of involvement, particularly stabbing a truck driver. Now, according to the court documents, Sanchez is set to appear in Marion County, Indiana on December 11th of this year. He faces 1 felony count of battery assault and 3 misdemeanor charges stemming from a reported confrontation with a truck driver. Now, the individual involved, 69-year-old Perry Toll, has initiated a civil action against Sanchez and his employer, Fox Corporation, seeking compensation and a jury demand. Toll's legal representatives assert that he endured significant and lasting facial scarring, impaired functionality, additional bodily harm, psychological trauma, and other losses due to the event. And in the prior weeks following his release from medical care, Sanchez was processed at the Marion County Jail and subsequently released on bond. A court order permitted him to depart the area, but mandated that he undergo booking and fingerprinting at the jail. Since he resides in California, Sanchez had journeyed to Indianapolis to provide commentary for the Indianapolis Colts versus the Las Vegas Raiders football matchup that the purported dispute occurred prior to the game. The updated probable cause statement details that Sanchez confronted the truck driver employed by a firm handling fryer oil maintenance at the Westin Hotel delivery area, and footage from the security cameras depict Sanchez informing the driver that the parking was prohibited there and entering the vehicle's truck's cabin uninvited. As Toll attempted to contact his supervisor, Sanchez allegedly prevented him from accessing his phone, and the encounter intensified when Sanchez purportedly pushed the driver, prompting Mr. Toll to deploy pepper spray in response to the push. Toll informed police that he believed that the assailant intended to cause him fatal harm, leading him to draw a blade, and inflicted several stab wounds during the struggle. He described being propelled onto a waste container and collapsing onto the ground platform as well. From that position, he observed only approaching footsteps, perceived the scenario as a matter of death and survival. Toll recounted regaining his stance, and upon Sanchez's new advance, delivered a final stab. Sanchez then exhibited a startled expression, pivoting slowly, and escaped northward via the alley. So obviously he's got another court date, and we'll see how that goes. My guess is there'll be some sort of resolution that he will avoid a felony conviction, and there'll be a significant civil settlement to, kind of make that hopefully non-felony for Mr. Sanchez go away. Next, the Supreme Court says if you're a pothead, you shouldn't be a gun owner. That's right. Today, the Supreme Court announced that it would review whether individuals who habitually use marijuana may lawfully possess firearms, marking the most recent gun-related matter before the Supreme Court following their 2022 ruling that broadened Second Amendment protections. Now, the administration of Donald Trump urged the court to reinstate proceedings against a Texas resident accused of a felony for owning a firearm while admitting to consistent marijuana consumption. The Department of Justice filed an appeal after the federal appeal courts invalidated much of the statute prohibiting firearm possession by users of illicit substances. And in a related development last year, Hunter Biden was found guilty by a jury for breaching this statute, among additional offenses. His father, President Joe Biden, obviously at the time, subsequently granted him a pardon that he signed. Anyway, oral arguments are expected in early 2026, with a ruling expected by mid-summer. So although the Republican-led administration supports expansive Second Amendment interpretations, federal prosecutors contend that this prohibition represents a reasonable limitation on gun rights. The appeal seeks to restore the case involving Ali Daniel Hemani. His legal team successfully dismissed the felony accusation after the Fifth Circuit Court of Appeals deemed the comprehensive ban incompatible with Supreme Court's enhanced framework for gun rights. Nonetheless, the appeals panel indicated that the law could apply to instances where individuals are simultaneously intoxicated and in possession of a weapon. Hamani's counsel maintained that the statute's expansive language exposed millions to potential inadvertent infractions, citing federal health statistics showing that at least 20% of Americans have experimented with marijuana, and approximately half of the United States have authorized recreational cannabis, though it remains prohibited under federal law. The Justice Department asserts that the provisions is constitutionally sound when applied to habitual drug users, given the associated threats of public safety. This dispute highlights ongoing tensions in implementing the Supreme Court's updated criteria for evaluating firearm regulations. Back in 2022, the court's conservative majority determined that the Second Amendment typically permits public carrying of guns for persons for protection, requiring any limitations to align closely with the historical precedent of the United States. That pivotal decision has prompted numerous legal contests in various gun laws nationwide. All the justices have since affirmed a separate federal measure aimed at safeguarding domestic violence survivors by restricting firearms access to those subject to protective orders. Bottom line, ladies and gentlemen, my guess is Supreme Court's going to say, guess what? You can't be a habitual pothead and have guns. Just like if you're drunk with a firearm, that is a crime. Kind of makes sense, although I'd probably be more worried about a drunk guy with a gun than a pothead with a gun, but I guess it just makes you a big dud after all. So who knows? But I think the historical context with habitual drug users, the Supreme Court is going to say they can do that. But we'll find out at the same time altogether next year. Next, this day in legal history. On October 20th, 1857, the United States Supreme Court in Dred Scott v. Sanford. The arguments concluded on this date, and that was the rules that that was the case where the Supreme Court ultimately rules that African Americans are not U.S. citizens, and Congress lacks authority to prohibit slavery in territories, invalidating the Missouri Compromise and intensifying pre-Civil War constitutional debate on citizenship and federal power. And on this date, October 20th, 1973, Solicitor General Robert Bork fired Watergate Special Counsel Archibald Cox at the direction of President Nixon after Attorney General Elliot Richardson and Assistant Attorney General Ruckenhaus had refused to resign. And our legal quote of the day has to do with motives. Outward actions are a clue to hidden secrets, right? You know you want to get the CrimeTalk merch, the action to make it happen. And finally, our dumb criminal of the day. A Florida man claiming to be a DHS agent arrested for DUI with two kids in the car. That's right. A 42-year-old Miami resident, Scott Thomas Diesroth, is facing multiple charges after being arrested near the Florida Keys for driving under the influence and child endangerment. Well, this gentleman, who allegedly claimed to be an agent with the Department of Homeland Security, was pulled over by deputies from the Monroe County Sheriff's Office in August following reports of reckless driving. The two children, aged 7 and 9, were found inside the vehicle at the time of his arrest. Ooh, turns out wasn't a DHS agent. Oops. More charges. Ladies and gentlemen, don't impersonate a federal agent. That's bad stuff. All right, ladies and gentlemen, like I said, day got away from me. Sorry. Quick show, fast show. Hope you enjoyed it. We'll see you tomorrow. Remember, the Constitution matters.